Welcome, welcome, welcome back to our panel discussion for Korematsu Revisited. I just want to say thank you, thank you, thank you to the hours and hours and hours of editing that was done to create that script, to the enormous amount of preparation and performance that the actors did. They worked hard all day today to perform that text for you, and I was just blown away by their artistry and talent. And now we have an amazing panel of experts to help us understand all that drama we just experienced. So I first want to call up to the stage Farida Chahada. Farida Chahada is the managing attorney of the Los Angeles Office of Human Rights First, where she oversees the pro bono legal representation of indigenous asylum seekers. She provides support and guidance to volunteer attorneys in law firms located in Los Angeles, California, who represent asylum seekers at all levels of the immigration system. While our panelists are speaking, please keep putting comments and questions into the chat. We will be including you in the conversation. And now, Farida.
Thank you, Claudia. I'm very happy to be here today. In 2019, I joined SCOTUS Theater as a panelist for the Korematsu v. United States event. It was live at the time, and it was at the Japanese American National Museum in Los Angeles. We came together to discuss President Trump's Muslim ban and the through lines that we saw between that ban and Korematsu, the infamous Supreme Court case that upheld the internment of Japanese Americans during World War II. In that case, Chief Justice John Roberts, in a 5-4 majority opinion in Trump v. Hawaii, stated that Korematsu has nothing to do with this case, as we heard in the reenactment just a little bit ago. But like Korematsu and Trump v. Hawaii, the president invoked a national security threat to justify a sweeping discriminatory policy that significantly limited the freedom of a particular group. The majority heavily deferred to executive authority in matters of immigration and national security, that being despite the substantial evidence of religious animus in that case. Though now widely condemned, Korematsu exemplifies the dangers of judicial deference during crises, where constitutional liberties are subordinate to executive claims of national interest. During his first presidency, the Muslim ban represented probably the most prominent of Trump's policies, with Justice Sotomayor describing it as a policy masquerading behind a facade of national security concerns. And now, as we sit here nearly 7 years later, cases such as Trump v. J.G.G., Noem v. Abrego Garcia, and Khalil v. Trump highlight the emergence of a consistent pattern during the first 3 months of the second Trump presidency. That pattern is the expansion of executive power, often at the expense of constitutional protections, particularly in times of perceived crisis or under the guise of national security and immigration control. We see that manufactured national security threat in Trump v. J.G.G., which challenges the Trump administration's decision to invoke the Alien Enemies Act as a pretext to summarily deport 238 men it claimed were members of a violent Venezuelan gang called Tren de Aragua. There, the Supreme Court held that the Trump administration acted unlawfully when it removed people from this nation with no process. And parallel to that case, we also heard of the case of Mr. Kilmar Armando Abrego Garcia, who is a citizen of El Salvador living in the United States for 15 years when he was forcibly disappeared to the Salvadoran Maximum Security Terrorism Confinement Center, also known as CCOT, despite never having been charged or convicted of a crime either in El Salvador or here in the United States. In that case, the Supreme Court ordered that the administration facilitate Mr. Abrego Garcia's release from custody in El Salvador and his return to the US. However, this administration has refused to do so, stating that they don't have the authority to bring him back, much as they have done in Trump v. J.G.G., where a federal judge ruled that the Trump administration appears to have willfully violated his order to turn around the planes of migrants headed to El Salvador's CCOT. Both cases mark a departure from the Trump administration's previous compliance with court orders, and they raise serious concerns about the rule of law and the growing authoritarianism in the United States that we've seen over the past month. In another immigration case, which we also heard from, Khalil v. Trump, the arrest and the attempted deportation of Mahmoud Khalil, a lawful permanent resident and a Palestinian activist, raises serious First Amendment and due process concerns. The government admitted that Khalil committed no crime and he was targeted for his speech, setting off alarms about retaliatory state action against political dissent. His removal was justified on vague foreign policy grounds, echoing fears of guilt by association and showing the government leveraging immigration law to silence dissenting voices, especially those from our marginalized communities. Targeting Khalil sends a chilling message to millions of other immigrants, and that is that if you speak out, you could be next. In that same vein, we're seeing an increased retaliation against civilian institutions like law firms, activists, and universities who challenge government authority. Over the past month, the president has issued an executive order targeting large law firms like Covington, Perkins Coie, and Paul Weiss because they represent the president's political opponents or they've engaged in disfavored voting rights litigation. Likewise, we've all seen the president issuing a memorandum that targets the legal profession. He's forbidden federal arts funding from going to artists who promote what the administration deems gender ideology. And he's also threatened to withhold billions of dollars in federal grants and research contracts from universities who push back against this administration's threats to academic freedom. Across all 5 cases that we've heard reenactments from today, we see several patterns emerge. First, judicial deference to executive power, especially when it's framed as immigration or national security. Second, the use of vague or pretextual justifications, buzzwords that we've heard such as foreign policy, public order, or national security or interest to suppress protected speech or target disfavored groups. Third, the erosion of First Amendment protections and due process rights, especially for non-citizens and political dissidents. Fourth, an increasing retaliation against civil institutions. Policies appear to target individuals or groups based on their political beliefs or their affiliations, and it raises serious concerns about political repression. And lastly, it echoes historical abuses like Korematsu, warning of the cyclical nature of civil liberties violations during periods of political polarization.
Thank you, Farida. My goodness. I am so honored to have legal experts here to talk about this. I wonder if I'm kind of just looking at the stage and where we're scattered. And the next year is I think you're standing us to 2019, Jeremiah. So I think I'm going to call you up next because I'm just going chronological on here. You can interrupt me. Any of our panelists can interrupt me if you really want to go next. But I think I'm going to call up Jeremiah. Jeremiah Augustus Chin, they, them, teaches constitutional law, race, and the law, federal Indian law, and civil procedure. Their research emphasizes the connections between law and social science through critical race theory, examining uses of social science data in civil rights and federal Indian law. Their recent publications focus on the intersections of race, law, and indigeneity, analyzing the school-prison pipeline, Cherokee freedmen, and issues of Blackness, American Indians, and citizenship. Jeremiah, thank you so much for being here.
Thank you so much for having me. And first of all, thank you to all the performers and the organizers and folks coordinating tonight's event. It's been a real honor to be a part of everything and to really utilize the public attention that is being drawn to both the Supreme Court and the law in ways that are generative and artistic rather than just kind of the meandering drumbeat of the rule of law without any kind of depth or substance to it. Because I think for me, so much of this revolves around the idea of how the law operates and how we've failed to learn from our past, not just mistakes, but authoritarianism and fascism of the past that Farida was just very eloquently discussing. Part of the dissents in Korematsu versus United States, I think Justice Jackson points out very pointedly that there is a principle that the court is instantiating in the majority opinion through Justice Black's articulation of this standard that would become strict scrutiny, the idea that any governmental action targeted at one particular group must be narrowly tailored to achieve some kind of compelling governmental interest, actually comes from Korematsu and would later be used to overturn everything from segregation to affirmative action. However, that part of Korematsu is somehow continuing after Trump versus Hawaii, and no one minded Justice Jackson's dissent that I mentioned earlier, where Justice Jackson points out that a judicial opinion rationalizes an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order. The court for all time has validated the principle of racial discrimination in criminal procedure and transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law and thinking and expands it to new purpose. So when Justice Sotomayor calls out Chief Justice Rehnquist in her dissent in Trump versus Hawaii, noting that overturning Korematsu is really kind of ineffective and gesturing and pandering towards this ideal that we've moved on beyond racism that Chief Justice Roberts repeatedly likes to reaffirm, it further validates Justice Jackson's dissent in showing that this has created a loaded weapon that is being now pointed at different populations maybe, but is still revolved around this idea of belonging, citizenship, and otherness, particularly ideas around birthright citizenship that were pointed out so well in the performance before. The idea of Korematsu's loyalty to the United States being dependent on his citizenship, and then the justices defending him immediately pointing out that he's a naturalized and birthright citizen is very fascinating given the fact that one of the first attacks by the current administration towards persons in the United States is the attack on birthright citizenship. So invalidating any ideals of loyalty around this racialized perception of otherness and pointing this loaded weapon at new populations from Korematsu into student protesters, into anyone who the administration deems is unworthy of the protections of the United States national government, particularly given this blanket claim of national security. So just as history hasn't been learned from by the current administration, we also see that national security is this kind of ongoing ghost that haunts our jurisprudence that has been used at any time during United States history, during times of peace and war, in order to target those populations that an administration deems as dissident or even just simply different from its own. So nowadays we have it pointed at student protesters, like I mentioned, or anyone who even, might utter the word Palestine in a public setting that is deemed unfit by the current administration. That kind of rhetoric absolutely destroys so many elements of our democratic system that we have defended so well in times of peace. Look at the way that the administration has handled, not the administration, the Supreme Court has handled the Ku Klux Klan and the insurgency of white supremacist rhetoric in the United States following desegregation and Brown versus Board of Education. There, the court, I think maybe correctly, identified that the way that we handle our dissenters in this marketplace of ideas, as the court calls it, or maybe better to think of it in a less capitalist setting of a forum or discussion, the handling of dissent is really important in a democracy, in that we give those viewpoints some degree of respect and listening, but we just are only allowing the government to act if there is the way that the court phrased it in the most recent version of the Brandenburg test, which is incitement to imminent lawlessness. And so even then, we have to have some kind of affirmative showing by the government that there's some kind of imminent lawless or violent activity. But instead, out of the current administration, we have nothing but bloated rhetoric that points to any person who they deem as immoral or unconscionable or illegal as a threat to the imminence of this nation. Even a tattoo or any kind of marking can be deemed as criminal activity, which unfortunately has been a long line of precedent in our Supreme Court, where they can use these pretextual markers to identify populations that are identified as other or any kind of group or social affiliation, when in fact our First Amendment also protects things like association. The rights of people to not only express themselves, but associate in groups and enhance that expression, kind of like we're doing tonight, is a vital part of our constitutional order. And so to attack those individuals who are speaking out, or even to attack persons who aren't speaking out to cause silence, is the most effective and efficient way of implementing this unconstitutional scheme of compliance and complicity throughout our administration, because for it to affirmatively state these orders directly, to use the pretexts that were talked about in the presentation, like a proclamation or a national security check for immediate authorization as a pretext for the Muslim ban, as the tweets of the president indicated, have created this very untenable system. The loaded weapon that Justice Jackson was talking about even goes a step further, where Chief Justice Roberts enables it so much more in Trump versus Hawaii, where he says that if there is a constitutional justification for the executive order, then the court will have no other choice but to affirm it, even if the president in public statements in private settings as a candidate has identified it as a wholly discriminatory, racialized system of excluding certain populations of people. So now the court has not only consolidated its power in determining what's an official and unofficial act after Trump versus United States, but the court is also the determinant of what can be dissent, or what can be valid, or what can be constitutional by the administration, and give them enough cover that even if they propound some kind of poorly formed bad faith legal argument, that the Supreme Court is able to save it in order to save some norm of constitutionality by sacrificing the entire Constitution itself. So my final thought for all of this, I think, is that these repetitions are embedding in our jurisprudence, in our way of thinking, in our national discussions, the ideal that there's going to be some sort of salvation or justification that's going to come for the problems that the administration is creating. However, I think that we need to start looking to how we are treating each other and how we are protecting each other and speaking out for each other. That really becomes the focal point of how and in what ways that we can push back against these unconstitutional attacks on people, democracy, and even the concept of mutual aid in and of itself. The real problem that I've noticed, especially among folks on campuses like mine at the University of Washington, is that you have a lot of folks who are very nervous and looking for others to speak up and initiate the conversation because they're afraid of what positions might be authorized or unauthorized. And I think this is a real time for all of us to speak out and speak clearly and in solidarity with each other. Thanks.
Thank you, Jeremiah. I'm off camera and off stage because I'm literally freaking out in the audience and just being like, yes, Thank you. I'm just so grateful to have you as experts articulate this so well. We literally have little audience avatars dancing because they are so moved by this speech. I just moved my avatar to stand next to Mia Yamamoto. So I thought I would invite them to speak next, and then we close out with Suzette. Again, I'm just going by the order on the screen. You can let me know if you don't like that order, but I thought I would invite Mia to speak now. Let me quickly read. I just have a very short bio for Mia. Mia F. Yamamoto, she, her, is a Japanese American transgender woman, trial lawyer, former public defender, currently in private practice. Thank you for being here, Mia.
Thank you. Can you hear me? I think I'm okay. I can't really add much. The academic level of excellence that's preceded my conversation at this point, I really can't add much to what's they've covered the field with respect to the litigation that's going on, a lot of the history of the litigation, the impact that a case like Korematsu could have, I'm sorry, in the current time. So I think that I'd rather talk a little bit more about what's going on a much more street level. There's a lot of people who are being harmed. People actually looked at the kind of conditions that Kilmar Garcia has been subjected to in El Salvador. They would be outraged if anybody that they knew and loved had been subjected to that, especially when they have never been convicted of any crime in either Salvador or this country. This is an extraordinarily important case. It's extraordinarily important because the President of the United States is using this case to show everybody that he's above the law, that the law doesn't apply to him. And it's extraordinarily important for us to take notice of this, and as a country and as Americans to stand up and say, no, we don't care who you are. You don't violate the constitutional rights of any person in this country, and we will continue to seek his release and his legal vindication. And that goes for every single victim who is harmed and who is placed in situations of jeopardy by this administration. And it's interesting, we do have to focus on this because what the president has done is he is making cuts and harming people all around this country in a whole bunch of different ways. And he's using his stooge, Elon Musk, to be the person who is going to be the vanguard of that mischief. But there are real people who are being harmed by this. And I just want to make it clear that these legal battles are not just something that's existing in somebody else's backyard. This affects all of us. And that is the reason that this should unify us. We can do nothing without each other. We have to unify against the tyranny, against the imposition of a fascist state. We cannot sit back and tolerate what is going on in a whole bunch of different areas, not just in the courts. But the courts themselves are extraordinarily important. The law is extraordinarily important. The only thing that stands between us and the monsters in the White House is the rule of law. That's why this case is so important. That's why all of us should pay attention and be speaking out on behalf of the limits that the Constitution places on every single one of us, including the president. And that's what a democracy is. And as soon as that is lost, our democracy is starting to be undermined, and it's the beginning of the loss of our democracy. It is the beginning of the loss of our individual and personal autonomy. The courts have already collaborated in the war against women, against the women's physical integrity, their personal autonomy. This coming after them is a prelude to them coming after the transgender people. I just want to talk a little bit about what it means to be a transgender person in the crosshairs of the administration. In one way, it's kind of an honor because his targeting of the most vulnerable and the most minuscule minority in America is so typical of the type of person, the kind of bully he is. I want to say that it's really an honor to be able to stand up for this community. He's trying to instill fear in somebody that has no fear of him or any of his shenanigans. I'm too far gone, I'm too old to care about what's going to happen to me. But if I don't stand up and speak, I can't go on with my life knowing that I passed up an opportunity to stand up and speak out on behalf of my community and to reach out in a way that I think is meaningful to all of us. I want to cite the great Frederick Douglass, who said, when he fought against slavery, it was for himself. When he fought against racial discrimination, it was for his people. But when he fought for the rights of women, he found some nobility there. And I think it has to do with our unity, our solidarity. All people are unified against tyranny, against injustice. Every single one should be on board with respect to the defense of the Constitution. I am a Vietnam veteran. I took an oath to defend the Constitution against all enemies, foreign and domestic. Donald Trump is an enemy of our democracy. He is an enemy of my Constitution. I have to stand up in my duty to go against tyranny that affects my fellow Americans, whether they are immigrants or non-immigrants. And I look and I don't see what is going on, that people don't notice that he is going after people of color. He's not just going after people like myself, LGBT people. He's going after anybody who is a person of color. He's trying to undermine the rights of women. He is doing everything he can to take away from what we believe we have built in this country that we call America. I just want to say that it's so important. All of us have to be caring about each other. This is a really important time not to give in to the kind of division that is being sown out into the community, not give in to the fear that is being attempted to impose upon our communities. Every single one of us is under the gun, and that means we should all be for each other. This is a time for solidarity. This is a time for unity. We have to stand up together. That's the only way we're ever going to be able to win against these people. And I know I'm not talking in the way I probably should, and this sounds like a pretty academic space here. But I just want to say, I'll give you my particular point of view. And yes, I was born in one of those concentration camps, and I have a history that my community went through this. All of the Japanese people went through those camps and got a taste of racism and how it is able to be enabled in the courts by the government. And the same things are happening now. The advancing of white supremacy starts with eliminating people of color, taking away their right to vote, disempowering people wholesale. And I want to echo the words of Dean Erwin Chemerinsky from the University of California at Berkeley, the law school, saying that I'm ashamed to be a lawyer. I'm ashamed to be in a profession where people are backing down wholesale against the Trump administration, coming after your programs, your DEI programs, coming after your policies, and then demanding millions, billions of dollars in pro bono services in support of right-wing causes. How can you let the most powerful, the richest people in my profession bowing down with such cowardice? And it's the same thing that's going on with some of the universities, and thank goodness for Harvard University. Thank goodness for an institution, an educational institution with integrity and with some measure of independence and courage. Thank God for people standing up finally. And we have to do that collectively. If to start now, we don't need further evidence of what's going on in this country. I don't think we need anything more than each other. And I still believe for all the people that voted for this idiot, that they can be brought around. And the people that didn't vote at all need to be addressed. And hopefully they can be persuaded. I want to say this on behalf of the community. Part of the community I represent, yes, Asian Americans, we are in solidarity with all of the members of the civil rights movement, that we are a part of the civil rights movement. We will always be indebted to the struggle for Black liberation that has powered the civil rights movement. And understand where we are now is that the administration is attacking and going after the civil rights movement. Every single community that has benefited from that struggle is being undermined by the current administration. We know what they're trying to do. It is a time for us to fight back on behalf of the movement that has done so much to benefit us. Too many people have laid down their lives and their careers to advance us to where we are and to have us stand complacently by while the government goes out and undermines and undoes all the progress of the last 50 or 100 years. I am speaking from the heart, and I will just say that that's what matters to me in this particular struggle, is that we are all doing this together. It is all one movement. We have all benefited from the great civil rights movement. It is time to stand up for it again. And I want what my last thing I just want to say is that Black Lives Matter. They matter, and that I hear every time I pronounce that in my Facebook pages, some fool says all lives matter. And I was telling them all lives will not matter until Black Lives Matter. Thank you very much.
Oh, Mia, come on, Mia. It's a good thing I was off camera, because I was just doing this the entire time. Yeah. And I see it in the chat. Like, folks are going off. Thank you, Mia. Just everything you said was just right, and you're right on time. And just, I got to say, everybody's saying all the right things. And you're also helping me to understand that this thing we did, y'all, I was feeling like I was a little bit nutty butters maybe a few days ago. I was like, Claudia, what are you doing? You're surrounded by all these texts. You're trying to understand the law. And then you're going to bring people to explain it. And how is this going to make change or do anything? And I am seeing people in the chat, in all of these audiences. We're in like 4 different digital spaces, and it's really, really powerful. I just also want to do a big, gigantic thank you to all of our partner theaters, because Suzette, I discovered you through Crowded Fire Theater. Give it up for Crowded Fire Theater. It's an awesome theater company. Suzette, I just want, can I read your bio real quick? Would that be okay?
Yeah, sure.
All right. So Suzette Malveaux, she, her, joined W&L Law in 2024 as the Roger D. Groot Professor of Law. She comes to W&L from the University of Colorado at Boulder, where she was the Moses Latsky Professor of Law and Director of the Byron R. White Center for the Study of American Constitutional Law. She has taught civil procedure, complex litigation, employment discrimination, civil rights, and constitutional law for over 2 decades. Her scholarship explores the intersection of civil rights and civil procedure, as well as access to justice issue. Also, she was a civil rights lawyer representing the victims of the Tulsa Race Massacre of 1921. Suzette, thank you so much for joining us. We'd love to hear anything you have to say.
Thank you. Thank you so much. I just wanted to say I'm really grateful to be a part of this project. I think it's brilliant, and so I'm excited to be here. So I wanted to say that. It is hard to follow Mia, but I will do my best. I was like, ooh, amen. So I wanted to talk a little bit about some of the recent cases and how they sort of harken back to the older ones, Korematsu and Hawaii v. Trump. And I'm going to take a different angle maybe than some of the others have taken, and that is to focus somewhat on procedure. And so we know that, for example, in Trump versus J.G.G, the one dealing with Venezuelans being deported to El Salvador without due process, one of the things the court said and agreed on, like this was the unanimous part of the opinion, is they all agreed you have a right to, to notice and an opportunity to be heard, right? The due process is really important, and that you have judicial review. But I think what is going on in many of the cases that we see, Supreme Court cases, really the justices hiding behind procedure, right? And we have to be really careful about that, right? So they may be weaponizing procedure, or they may be hiding behind it. So if you think in that case, the majority were claiming that this question is really narrow, right? That the only question that you really have to deal with is like the location of where these particular Venezuelans, where their claims going to be brought, right? Are they individual habeas petitions that are going to be in the place of confinement? So that would be the Southern District of Texas. Or are they going to be over here under the Administrative Procedural Act where the class action is filed? That would be in DC. So it's sort of like kind of narrowing it down to this very small issue, right? About just the location of where this is going to take place. Well, definitely location matters. right? It is no accident that we are talking about DC versus Texas for where this is going to happen. And so some of those cases, and this one in particular, I think sort of takes cover in this neutral, objective, sort of antiseptic way of thinking about the law and what the question is before the court, really outside of a context, right? And context really matters, right? So if you think about the context, and I think Farida, you had mentioned this, and Mia, certainly, when you think about the harms that come to individual people and how dangerous it is to have people deported to El Salvador, right, to a notorious brutal prison, right, where people are tortured and so forth. So we're thinking about real harms to real people. And if you also consider the context, we're talking about an administration that seems to really be flouting the authority of the courts, right? And you have in this case, you have a district court judge, which is really saying, hey, I think we've got, we're skirting on having probable cause here, that there is criminal contempt of court, right? So this is the kind of context that this is happening in, but the court is making these decisions somewhat in a vacuum. And then the other thing I would say that I think permeates some of these decisions is really thinking about the court's perception of its own role. Like, what is it tasked to do, and really abdicating its responsibility to be a check and a guardrail on the abuse of executive power. Again, in this case here, you're talking about, we have court deference to military, to foreign policy, to national security. In the case deporting folks to El Salvador, I mean, we're not even in a wartime, and the administration is actually pulling from the Alien Enemies Act. And so it doesn't take much for the court to sort of say, hey, not my lane, this isn't my job. So something to sort of keep in mind. I think I will say, I should go back for a second. I think one of the things that happened that is pretty powerful in this case is, and many of you probably know this already, but 1 o'clock in the morning, it was rough, but 1 in the morning, the Supreme Court did say in this case that, and thank God, that this is not just procedural, right? We seem to have some shift, that there is going to be somewhat of a due process protection, right, for people, keeping people from being deported to El Salvador with no due process consideration whatsoever. And so, in fact, this happened, right, like I said, very early in the morning, but the Supreme Court, there were dissents from Thomas and Alito, but the court said that the government is directed not to remove any member of the class of detainees, right, from the United States until further order. So there's a shift, which I'm hoping is maybe going to indicate that the court is sort of waking up. There's a lot of smoke, so there's fire here, right? And so we need to take this pretty seriously. The other thing I thought, thinking about the Mahmoud Khalil case here, is, again, it's about procedure. The court is kind of, and I talk to my students a lot about, procedure is really the game, right? Like, that's where the action is happening. As unsexy as it is, that's really where a lot of the rubber hits the road. And again, the court is saying in the case of Mahmoud Khalil, hey, this is just about transfer, right? This, again, is about location. This case, where should this person's case be heard, right? Is it New York? Is it New Jersey? Is it Louisiana, right? And that matters, right? So that makes a real difference. And again, the court being very deferential to what the executive branch is saying, right? Which is that this individual is his mere presence in the country, right? Again, hasn't been found guilty of anything, but his mere presence alone is a threat to foreign policy. And that's enough for the court, again, to sort of back off of what I think is really their fundamental duty in terms of checking the executive branch in terms of abuse of power. It's interesting because in that case, the dissent is leaning into Marbury versus Madison, right? That's sort of invoking that seminal case about the duty of the court where there's a wrong to provide a remedy. And this is a court that's really backing away from that and not leaning into the job of being a guardrail or a check on abuse. And I guess finally, I would note now, maybe this will come up in Q&A, but I would note in the Trump versus Hawaii case, one of the things you may have heard when you heard the actors who did a beautiful job, there was a concurrence by Justice Thomas who mentioned the nationwide injunction, right? So which is a remedy. And again, it was sort of like a throwaway comment, but not really, right? And he said the nationwide injunction, which is when you have a singular judge in a case who is whose remedy is going to be nationwide, right? It goes beyond the scope of just the parties in front of the judge, but hits everybody in the country. Justice Thomas was saying that's inappropriate, and that was in the context of the travel ban under his first administration. And so Justice Thomas is saying, no, again, this is one of those really important checks on the executive branch where there is abuse. And he said, someday we're going to have to deal with that. Well, that day is here. That day, in fact, is May 15th, to be exact, where the Supreme Court, in fact, is going to hear whether or not a singular judge has the authority, whether they have under the Constitution, under the rules, under powers of equity, to stop executive power, right? That is where there is bad faith. Can they do that? And that's happening in the birthright citizenship case, which will be happening on May 15th. So that oral argument will come up. And that's something that I think is really important to pay attention to, right? Because the uptick that we're seeing in nationwide injunctions is directly in proportion to the uptick in all of these executive orders, right? And policies coming out of administration, which is doing things that are illegal and unconstitutional. And so you have judges from all over the country, from 5 different administrations, Republican, Democrat, from both sides of the aisle, that are saying, wait a minute, right? This is dangerous. This is, there's going to be irreparable harm. Some of the judges have said that this is blatantly unconstitutional power grabs. And so thinking about, making sure that the judges have the authority, in fact, to push back from abuse of executive power. So I'm happy to stop there, but I can talk more about it. I can talk for a long time about nationwide injunctions and why they're so important.
Y'all, I could hear you talk all day long. Yes, I'm seeing like everybody is clapping it up here in the Gather Town. I'm seeing the tiny little cartoon claps. It's amazing. Yes, woohoo, 100. Yes, yes, yes. Y'all, I could hear you talk about this all day long. And I just sat here wishing I had you on speed dial. We have people in the audience just saying they are so grateful for your clarity. And also they've got questions about, and I will be honest, my lack of expertise means that I'm not sure what their questions are specifically towards in what you were talking about. So I'm going to apologize to our amazing audience. Although it turns out, I think there's possibly a lawyer in there and is helping them out. So I'm going to apologize that I'm not lifting up any questions from the chat into this room, but I did want to give just a quick moment for some crosstalk and maybe a chance for you to respond to one of the questions that was brought up. So you sent us some topics you could potentially talk on, and apparently I accidentally erased them or something, or they were in front of my face and now they're no longer there. I'm not sure exactly what happened. So I will invite you.
Hi, Claudia. It's me, the disembodied voice of your stage manager.
Hello, stage
I pushed the questions to the top of the page for easy access.
Oh, that's amazing. I just
clearly did not work. I apologize.
I was mystified and did not think to scroll to the top of the page. Thank you for that. And everyone, just witness the beautiful way we work digitally all across the country. I feel like this is an example of what a country's supposed to be like. So here are some of the amazing questions you asked. This is from the chat. So this is a question from the chat. When you saw vacuum, when you saw vacuum, did you mean they are not considering the collections of his actions? So that was referring to Trump. Yeah, I assume that when I brought the question to you, it would be without context and you would have trouble responding to it. Again, I apologize to our audience. Let me bring up one of the better questions y'all brought up. Are there other ways the Supreme Court is using procedure to undermine people's constitutional rights and access to the court? And
Sure.
Suzette, you brought up Justice
Yeah.
Thomas bringing up nationwide injunctions in Trump versus Hawaii. So if you want to speak it all on that, please feel free.
Yeah, and I'm sorry. I think maybe even the question before that talked about a vacuum, that might have been mine, where I was saying that it seems that the majority makes decisions within a vacuum, meaning they're not considering the context around them in terms of the actual harms that their decisions can make. They're making it as if this is a very clean procedural, very question. And so outside of the context that we're in, and I think this is a really important context, because the pushback on some of the nationwide injunctions is that this is some kind of brand new, sort of newfangled Congress, the House in particular, a couple of weeks ago, passed something called the No Rogue Rulings Act, right? And so this is the way it's portrayed as like you have these rogue judges that have gone wild, right? And as usurping their own power and sort of taking it outside of a context. The reason you have this huge uptick, right, in judges who are using this kind of authority is because you've had hundreds of executive orders coming out of this administration within short order that are very dangerous. And so that's the context piece that I think is important. And what they're saying is, judges need to sort of step into the vacuum, and they need to check abuse of power. So if there is an administration that is not acting in good faith, so again, we have the birthright citizenship example is a great one. It's sort of blatantly unconstitutional. I mean, it's in the text of the Constitution. You have people who are transgendered who are forbidden from participating in the military. You have people who are losing their jobs. There are all kinds of ways that people are being harmed. And so an injunction is important to stop that, not only for the people who have the privilege of bringing a case, but also for everybody nationwide, right? Everybody nationwide could suffer for months or years if we actually don't have emergency relief, and if we don't have judges that are brave enough to step up and fill the void. So it's Republicans and Democratic judges that are issuing these injunctions against the Trump administration, because I think that they are seeing the danger there. The Supreme Court has done this in other ways, and this is a sort of longer conversation, but there are lots of rulings that have come out of this court within the last 50 years that have made it harder and harder for everyday people to get access to the courts and just bring their case at all. And so those barriers are increasing, and we don't notice them because they're sort of under the radar. They're not very, they're not really grabbing headlines, but they make a real difference. If you don't have the procedure there, you can't enforce the substantive rights that people have fought so hard for. So I think that's a real problem.
If I just might chime in a little bit, I think when the president issues an executive order, it's nationwide. So the attack on the order should be also applicable nationwide. And here's the reason why. It's a much more practical, certainly, to have it resolved in a court. And if it needs to go up and be reviewed ultimately by the court, by the Supreme Court, then it's got a proper procedure that's always been employed for that passage to get to that place and be decided in that way. For Clarence Thomas, who has probably the least credibility next to Alito on the port, to be objecting to it made me kind of wonder why that would be, because it's certainly not an efficient way to resolve things just to have every federal judge in the country taking a different point of view on a case. It's better to have it resolved in one litigation going up vertically. So I couldn't figure out what Clarence Thomas was objecting to, except that it was annoying his boss.
Just to jump on one quick procedural point too that Suzette mentioned, like getting on the procedural hurdles that the court has kind of constructed. There's also a procedural fast track the court has constructed. And so the emergency docket and the shadow docket that we saw really exploited a lot during COVID, but now is being used in cases like emergency deportations, where the Trump administration says that they're going to take it to the Supreme Court, and then that allows Alito or Roberts or Thomas or one of the justices, right? This is why location and geography matters too, why there was so much fight over Louisiana versus New Jersey, is knowing which vertical shadow docket you're going to come up through and how quickly it can go up to the Supreme Court, because it isn't just about the lower court judges, but it's about which of the justices is the designated justice for that particular region, right? And so where cases get filed has as much to do with which justice do we want to appeal to, such that they will make an argument for us to be put on the regular docket or the shadow docket. And so you have a lot of, I don't know, cloak and dagger kind of procedures that are happening at the Supreme Court that are really dubious versus a profession that is, frustratingly, but sometimes delightfully procedural in its nature, and needing to go through all of these steps in public to do so behind closed doors so frequently is really, really distressing, I think.
I have an audience member who would like to, they don't understand what an emergency docket is or what a shadow docket is. Could you explain what that is?
So, usually the court takes a case on a writ of certiorari, right? Where, you have to put through your full appeal to the court, and the court chooses which cases it's going to take and which ones it won't. The emergency docket or shadow docket says that the relief asked for is so pressing that the court needs to rule on it immediately, before having oral argument, before completed briefing, before a full hearing on the appealed facts, and just looking at the record, give us a quick hot take from the Supreme Court, right? Essentially what the shadow docket does. Sometimes you'll get a written order off the shadow docket, and sometimes you don't. And there's no preset rules for that. And that's a part of the problem too, is that we don't have clear lines on how, where, and why the justices are voting, right? Just on one of the more recent shadow docket orders, we have an Alito, the one that Professor Malveaux mentioned that happened at 1 a.m. last night. Justice Alito's dissent is still pending. He's gonna write a written dissent. We don't know what it says. We don't know what it's going to say. Obviously, he was very much outvoted on the issue, but he has something to convey. And there might also be, responses to that dissent, or concurrences in the judgment that we see out of the court in writing later on, long after the opinion has already been ruled on, versus the usual procedure at the Supreme Court, where the day it announces a decision, all of the opinions are ready, right? So it's kind of flipping procedure on its head.
I would like to, yes. All right. So one more question from the audience, and then I think I'm going to give us a chance for people to say final comments, and then we can close ourselves out. So the last question here is, why do we think they got it out before Alito's dissent? Actually, you know what? I'm going to ask the more complicated question on here, because I want to know the answer to this one. Y'all, this was a dramaturgical nightmare, because case law was being made every single time I edited the script. So I'd finish editing it, and then they'd make more law, and I don't remember law happening so fast before. So it's been a process, y'all. So how did Khalil's case end up in Louisiana after the New Jersey judge said that the case had to be heard there? We ended up reading that ACLU excerpt because that Louisiana judge on April 11th said that Mahmoud Khalil could be deported. And we were like, wait a second, I thought we were in New Jersey. How are we back? How'd that happen? Can anybody explain it to me? It's okay if you can't.
It's quite common for individuals who are detained through ICE to then be placed in a CBP hold, right, at a CBP office, which is probably what happened initially when he was picked up, right? And then what happens is that once you're detained, you are often transferred between detention facilities very quickly, and you can be moved across the country. And this is very common with some of our detained clients who could be living in Los Angeles, end up getting detained, for example, in Adelanto detention facility, and then end up in Louisiana or end up in Florida, for example. And some detention facilities and some particular immigration courts are known for being notoriously anti-immigrant. And so you end up in a situation where you can really be disadvantaged based on who is hearing your case and which detention you're in. And Louisiana is notorious for that. So both Louisiana and Texas, for example, and some of their detention facilities have been the prime locations where non-citizens who are picked up by ICE end up getting sent and then held pending whatever type of immigration process is going to proceed moving forward. And so that's what happened here, despite the judge instructing that Mahmoud Khalil should remain where he was initially detained. But then we ended up with a situation where the government was, well, we don't know where he's detained and he's been transferred around, and he's now in Louisiana. So that's where he currently is. And so it was there that the immigration court and that specific immigration judge heard his case and issued the decision that he was in fact removable, and that essentially his green card can be revoked based on the Marco Rubio. That was essentially the only evidence that was submitted on that case, indicating that, he was a threat to foreign policy based on his statements. And it was on that basis that, the judge ordered his removal.
It feels like a real complicated trick where the president can write a proclamation or an executive order with a bunch of stuff in it that feels real made up. And then the Secretary of State can say, well, actually, this proclamation, this executive order said all this stuff, so it's true. Therefore, allowing Mahmoud Khalil to stay in the country would endanger every single Jewish student in the United States. That 2-page memo was a read, y'all. I was shocked by the claims it made in terms of the danger of Mahmoud Khalil. I laughed out loud. I read it with an audience, and we all laughed at the dramatic claims it had in it. I appreciate you all helping us to understand all of this. As we close out, I just want to give a moment for people just to say some final remarks. I think I've learned my lesson. I'm now going to go by the order of the windows at the top of my screen. So I'm going to invite Jeremiah to say some closing remarks, Farida to say some closing remarks, Suzette to do some closing remarks, and then Mia, you get to take us home. Before I allow you to say your closing remarks, I just want to say thank you. Thank you all for being a part of this. And know that this Gather Town space that you're witnessing right now, it's open. It's open until April 23rd. Come here and learn more about it. We have action. We have learning modules. If you want to listen to an entire Supreme Court case text, you can in here. So come join us later. But for now, let's close out this moment. Just thank you all so much. And we'll start with Jeremiah.
Thanks so much. I think for me, the big takeaway message from all of this is just the recurrence of history that we see both in the play, but also in our subsequent conversation, even very recent history in the procedural discussions of the court. And how easily it is invoked, this claim of national security. The only party, unfortunately, who seems to be learning their lessons of the past seems to be the current administration and its attorneys, because I've seen parallels to some of the cases we didn't talk about, which were the detention and Guantanamo Bay cases. And the Supreme Court there ruled that because Guantanamo Bay is under the control of the United States, it falls within U.S. sovereignty and therefore due process and rights are due. And now the country has started exporting people to entirely different nations and kind of waving its hands and saying, well, we can't control them. We're not their bosses, and neither is the court. And so this is a huge, important piece that folks need to not only speak up and out for each other, but also pay very serious attention to those in power and with authority and how they are weaponizing that authority. So much of what I see in the current status of the law is what I've come to think of as trickle-down authoritarianism, where now everybody is expected to act with the kind of executive power and deference to authority that is expected of the president when in fact they are owed none. So thanks.
Farida, please go ahead. I'm so excited. I'm just like, yes, yes, trying to keep myself calm because I know I'm on camera. Farida, closing remarks?
I will say it's really nice to be here with everyone else who's interested in discussing these types of topics and who's really motivated to stay involved and to continue fighting against what we're seeing as the erosion of legal and constitutional rights here in this country. And I think it's very easy doing the work that we do every single day to become disheartened or feel this like impulse to disengage because the current climate is so bleak and so scary. But I think it is important for us to continue recognizing the privileges that we do have, whether that's, an education and degree to be able to advocate on behalf of others, or whether it's your background or your immigration status, and to continue advocating for vulnerable communities that are most impacted by a lot of these policies. And to remember that forgoing our power and disengaging only adds to the power of the executive, right? And so we do need to remain engaged, and we can't give up, and we need to continue fighting for the ideals that, America stands for and that we continue to espouse. And so that would be my takeaway, I think, from all of this.
Thank you. Yes, Suzette.
Thank you. And Claudia, we feel the same way. It's a nightmare, a dramaturgical nightmare. It's a nightmare on so many levels. What the law is on every day, there's something else, and it's meant to overwhelm, right? So we just have to deal with that fire hose of crises that come, and chaos it's meant to, and fear it's meant to invoke. But I would say, kind of along the lines Jeremiah has said, and things have come full circle. I think these things are not new. It's no accident that here we have on May 15th, right? This question, the substantive and procedural questions that will come up, the birthright citizenship issue, right, is here. Something that 125 years ago, the 14th Amendment, it is the very first part of the 14th Amendment. It was meant to address slaves, right? People who were born in this country from those who were slaves, overcome the Dred Scott decision, and fix that so that Black people had citizenship in this country. And here we are 125 years later with that being challenged and questioned by this current administration. And so so I think that is very telling. And I think we've come full circle procedurally, right? When we think about the first Trump administration and this whole balking at nationwide injunctions, fast forward, this is exactly where we're going to be on May 15th. And the same arguments that Congress is swallowing, the same arguments that are being made are the ones that, will apply today, right? Nothing has really changed. So I think it's really important to support judges, right, and help them hold the line, right? These are really perilous times. You have judges that are being personally, their safety and the safety of their families are being challenged, right, or threatened. They're being threatened with impeachment. They're being sort of mocked and so forth. And so I think it's going to be really important to get behind the judiciary as one of the last frontiers in terms of checking abuse of power. And it's just more important today than ever.
Yes, yes. And also your language makes me think that I possibly will need to produce more theater on this topic in the future. In many ways, all the world's a stage. And, I think about this case, the Korematsu case, and the people who are it's drama. It's the drama of creating justice. And yet we are still in the same play. I would like to be in a new play. I'm done with this particular plot. Mia, bring us home.
Okay. I just want to join in the remarks of my colleagues here. I just really am so thankful that you're putting on this production, that you're giving the words that you're giving. Certainly every single one of these professors has got a better brain than me. So I get out here and I'm the activist wing of the group. I just want to say, thank you to everybody. I want to just say that showing up is so important. People showed up for this panel. Your actors showed up to read. This audience showed up to hear about what's going on, and we're trying to give them some of the things that matter with respect to the facts. But I want to talk about is getting together with each other, finding organizations or forming organizations. It's time to get together and get together with everybody that you can get together with. There's a lot of good people in this country. There's a whole bunch of them right here in this audience. And I want to make sure that everybody understands that the only way we're going to do this is with each other. It's got to be through solidarity. It's got to be through unity. It's got to be through communities and individuals coming together on matters of principle, on the things that matter to us, like equality and like democracy and the fight against Nazism and fascism. Our parents, the generation before us, gave up so much of their lives and their careers to fight against the Nazis in World War II. And to see them rising again in my own country is extraordinarily disheartening. Watching lawyers, big law firms, Fortune 500 companies and universities backing off in the face of the Nazi threat. I don't see anybody else joining them. Stop that kind of capitulation. I say it again, I'll say it right now. Any kind of complacency is complicity. Don't be going along with what's going on. Fight back, organize, speak out, stand up. It's time for us and the real patriots of this country to be seen, to be heard, and to be seen marching against the regime. Thank you very much.
Thank you,